Good morning, ladies and gentlemen. I'm Jawan. Today, my team members and I are going to discuss to what extent utility innovations, or in short UI, provide important and distinct legal protection in Malaysia. I'm now going to give an overview of our presentations. Firstly, I'll give an introduction of the historical background of adopting utility innovation system in Malaysia. Following that, I'm going to talk about the largest distinction between UI and patent law in Malaysia, which is the exclusion of an inventive step. Next, our second presenter, Yuju, will deal with the importance of this exclusion of inventive step, and also put forward another three distinctions, which is local novelty, compulsory license, and a number of claims and their importance in providing legal protection in Malaysia. The third presenter, Jahua, will present on the fifth distinction, which is lower cost in applying UI and the importance of it. After that, she will evaluate the practicality of UI system regarding the sufficiency of the legal protection provided by UI. Lastly, Kasim will be dealing with another two costs and disadvantages of UI system and sum up the discussion. Generally, the acquisition of patent protection requires the patent applicant to satisfy the rigorous demands of the Patents Act 1983 listed in Section 11. The patentability criteria includes novelty under Section 14, the product or process must involve an inventive step under Section 15, and the product or process must be industrially applicable under Section 16. The prerequisites are exacting, and the procedural steps that have to be complied with are detailed, time-consuming, and are often costly to the inventors. Therefore, in 2006, Malaysia has acceded to the Patent Cooperation Treaties in accordance with the TRIPS Agreement and introduced a second-tier patent system in Malaysia, which is known as the Utility Innovations. UI was defined in Section 17 of the Patents Act 1983 as any innovation which creates a new product or process or any new improvement of a known product or process which is capable of industrial applications and includes an invention. There was concern that UI would unnecessarily compete with the existing patent systems without introducing any real benefits. Yet, many commentators support the introduction of UI as a fundamental intellectual property rights that provides important and distinct legal protection existing in addition to the patent system available. Firstly, the most significant distinction between an UI and patents law in Malaysia is that UI have lower requirements than patents, especially in terms of the threshold of inventiveness. Pursuant to Section 17A, Subsection 2 of the Patents Act 1983. According to Section 15 of the same Act, an invention is inventive when it would have been obvious to a person having ordinary skills in the art. The rationale for this exception is that it can fill a gap in the protection in the intellectual property laws in Malaysia, which occurs when the requirements relating to inventive step for patents mean that certain inventions which do not comply with those requirements cannot be protected. In fact, it is evident that there exist simpler innovations in the marketplace, though lack inventiveness, are worth being protected in laws as they are also commercially viable and are result of creative thinking, innovative activities, as well as the expenditure of time and money. Examples are minor adaptations to existing product and innovations in designs. Hence, it requires a distinct form of legal protection to serve as a tool to reward innovators and incentivize new innovations. This will be especially beneficial for Malaysia as a developing country seeking to advance our technological capacities through local innovations by small and medium-sized enterprises, or in short, SMEs. In developed countries such as United States, a second-tier patents law has never existed, as most of the innovations and inventions do not emanate from SME, but rather from large transnational corporations and the level of competition amongst these firms is high enough to maintain the incentive and momentum to create. However, Malaysia consists of more SME than large companies. WIPO recognizes that innovations by SMEs mainly consist in non-inventive innovations. In many such sectors, SME innovations are to a large extent of an informal nature and without formal research and development investments, laboratories, or personnel.
This table shows that the highest numbers of utility innovations encompasses innovations relating to human necessities such as footwear, furniture, agriculture, and traveling articles. These are areas in which individual innovators and SMEs could be involved in the creation of incremental improvements without the use of high technology. In this context, UI plays a bigger role than patents in providing a competitive edge to SMEs. This is in line with Malaysia's policies intended to strengthen the position of SMEs and achieve the target of the Ministry of Entrepreneurial Development to produce 1 million SMEs in the next 5 years. Furthermore, the lower threshold also led to the possibility that if one failed to convince the examiner that a sufficient degree of inventiveness had been demonstrated to permit patent protection, the application might, in cases where the subject matter was appropriate, be converted into one for a UI as provided in Section 17B, subsection 1 of the Act. This provides an alternative route to the inventors to seek legal protection, and the ultimate objective of Malaysia in reaching an innovative economy can be achieved. With the exclusion of the requirement of inventiveness, a UI need only be new and industrially applicable. An innovation is industrially applicable if it can be used in any industry, as stated in Section 16 of the Patents Act. This requirement is the same as one of the patentability criteria. It reinforces the meaning of an invention in Section 12 as an idea which permits in practice the solution to a specific problem in the field of technology. However, the novelty requirement for a UI application is different with that of patent. According to the modification to Section 14 of the Act, made in the second schedule, a UI needs only to be new to Malaysia, that is, it must not be anticipated by a prior art as prescribed in Section 14, subsection 2, subsection A of the Act. It gives a distinct form of legal protection as an innovation which has been disclosed in anywhere outside Malaysia cannot be protected as patent, but it can be protected as UI so long as it is new to Malaysia. This approach provides an incentive to bring technology to a developing country such as Malaysia. It supports imitation of foreign designs, which encourages local innovation, where in fact, imitation is an essential stage in learning to innovate and can even be creative itself. Especially in this era of globalization, the development in telecommunications render local novelty almost impossible to achieve in practice, as a new technology can be transmitted across the globe via the internet in a matter of milliseconds. Therefore, there is a sound argument that anyone prepared to put effort to import a technology that really can satisfy the local novelty requirement should reserve a monopoly right. Thirdly, the exclusion of Part 10 in UI application as provided in Section 17A, subsection 2, means that UI are not subject to compulsory license provisions. Compulsory license provided in Section 49 is an action of a government forcing an exclusive holder of a right to grant the use of that right to the others. The granting of compulsory license of patents rights is justified on the basis that compulsory licensing of pharmaceutical patents sometimes becomes inevitable to save lives of the populace by ensuring accessibility of drugs at affordable prices. It can be used to break up monopolies and abuse of patents rights. However, it does not apply in UI, as compulsory licenses should only be granted in specific circumstances, such as in public health crises. UI generally concerns minor inventions which normally would not cause such specific circumstances to occur. Hence, the need to grant a compulsory license would not and should not arise in UI, as incentive to innovate and create new works should not be diminished as a result of compulsory licensing. UI gives sufficient legal protection to the right holder as it does not interfere with his exclusive rights of the innovation. Fourthly, unlike a normal patent, where more than one claim can be applied for, in the case of a UI, only one claim is allowed. This was provided in the modification made to Section 28, Subsection 1, Subsection D in the second schedule contained in the Patents Act. The basis behind this restriction in the number of claims is that since UI is representative of simpler advances with lower innovative quality, large number of claims will be rare, and allowing such claims is unwarranted. This will needlessly complicate a process that is meant to be simple. Therefore, the owner enjoys a 100% exclusive right, which prevented the others from using his product or process.
Fifthly, UI has a lower application and maintenance cost and simpler application system as compared with a patent application. Generally, SME and individual inventors are more inclined to use trade secrets rather than patents as a form of protecting their inventions to stay competitive. The main reasons given by them for shying away from patenting their inventions, including high costs and complexity of the patent system. However, trade secret is not effective as many inventions are vulnerable to unfair copying, especially the sub-patentable ones, as they usually will be based on small-scale, incremental advancements of the existing state-of-the-art and are easier to be imitated or copied than technological breakthroughs. In such cases, UI can address this protection gap and prevent free riding by copying or imitation. This makes UI a useful tool for improving the competitiveness of SMEs and individual inventors and encouraging local innovation. This is particularly true and is proven by the research findings done by the Malaysian Intellectual Property Office, or in short, MAIPO. Turning to the proportion of UI applications coming from companies and individuals and comparing the numbers with patents, researchers find that from the year 1999 to 2003, 65.8% of the UI applications came from individuals. However, 96.2% of the patents applications came from companies and institutions. It might appear from this that individual inventors find that UI system to be more accessible than the patent system. With UI, it creates a new incentive for the development, production, and commercialization of products based on such minor or incremental innovations, as the inventors may have exclusive rights towards them. The impact is huge, as it engenders and facilitates innovation which will not only benefit the members of society, but also the nation as a whole. Large companies can also be benefited by UI system, as it allows the companies to stay competitive. Generally, it takes time for the research and development for big inventions to be done. However, in between this period, there might be some minor innovations to the previous products which do not fulfill the high threshold of patentability prerequisites. In this context, UI provided an alternative road for the large companies to seek legal protection and obtain an exclusive right in their minor innovation, preventing their competitors from free riding or taking advantage of them. In addition, if the innovation is expected to be outdated in the market quickly, a company may consider to apply for an UI instead of a patent, which may be obtained quickly with lower costs. Despite the distinctiveness and importance of UI system, it was argued that UI is actually impractical in practice, as the legal protection being provided is insufficient. This is evidenced by the statistics of application in MAIPO for UI, which is minimal compared to patent. This is illustrated in this table. The reason attributing to the low number of UI applications in Malaysia are that, firstly, the close proximity of Malaysia UI regime to the patent system. In particular, the need for a substantive examination procedure. seems to inhibit a more widespread use. Even though UI application omitted the criteria of inventive step, the treatment received will be the same as of patents applications. The earlier applications will be examined first. Thus, UI applications will have to wait for its turn to be examined, with UI applications pendency period being the same as of patent applications. Applicants prefer to apply for patents. Secondly, applicants prefer to be granted with a total automatic protection period of 20 years without the hassle of providing proof of utilization after the 10th year. According to the modified section 35 subsection 2, before the expiration of the 10-year period, the owner of a certificate of UI may apply for an extension for 2 consecutive terms of 5 years each. However, Section 35 subsection 3 requires the owner, when applying for an extension, to prove that the UI is in commercial or industrial use in Malaysia, or satisfactorily provides an explanation for its non-use. Therefore, while the system may have a place in the intellectual property system of Malaysia, it does not seem to offer a quick and better alternative to patent protection. Although reduced costs and a lower threshold for protection may be attractive, especially for local SMEs. However, the long examination period, the limitation to only one claim, and the need to prove domestic use in order to obtain the full term of protection appear to make the system unattractive in practice.
Besides that, the need of the introductions of a second-tier system to protect minor or incremental innovations is also doubtful. One point of critique that has been raised by a commentators, Sutarsana, appeals particularly relevance in the content of SMEs in developing countries. There is a reasonable concern that larger market players may use UI as a means of circumventing the more stringent criteria under the patent system and abuse the UI system to the detriment of SMEs. This is particularly true as the applications requirements for UI are easier than for a patent, and the exclusive rights enjoyed by the inventors are the same. Not to say that the costs are also lower. Most importantly, under UI, there is not compulsory license. Therefore, the owner of the UI literally owns a monopoly right. Eventually, there might be less tendency towards inventing, which require more effort in terms of time and money, as people would not want to go through the hassles to invent when legal protections and economic benefit can be provided by UI in a far more simpler way. This will defeat the main purpose of the UI system, which is to establish productions at a lower threshold for incentivizing innovative activity below the patent level. Therefore, there are suggestions that UI rights should ideally be restricted by other rules that would prevent their abuse. For example, the rules on compulsory licensing, which has been expressly excluded in the UI system in Malaysia. The other main argument which has been forwarded against the introducing a second-tier system to protect innovation below the patentability threshold is based on the concept of public domain. The traditional notions IP protection rests on the idea of protecting creative work. Under copyright law, distinctive signs as trademarks and inventions under patent law. If the latter do not fall under the patentable subject matters and fulfill the accepted conditions of novelty, inventive step, and industrial application, then no protections apply and the relevant innovations remain in the public domain. This allows everyone to utilize, exploit, and build on such unprotectable subject matter. Introducing another layer of protections below the threshold established by traditional patents protections requirements, on the other hand, results in a newly protected subject matters to be taken out of the public domain. Thereafter, no one can freely use it without the authorizations of the right holder,
or within the boundaries of an applicable exceptions or limitations to the exclusive right. This shifts the balance between access and incentive in a significant way and therefore should not be decided lightly. This is in accordance with the view of some commentators that in a market-based economy, it is generally accepted that all market actors, including competitors, follow-on creators, and consumers, should be allowed to freely use any word which falls short of the required standard. Indeed, as some courts or jurists have argued, copying and free riding is necessary, if not beneficial, for competition. In conclusion, utility innovations provides important and distinct legal protection in Malaysia. It lowered the threshold for patentability by removing the requirements of involving an inventive step, focused on the local novelty instead of global novelty, and allowed for a quicker, simpler, and cheaper application to protect valuable innovation, which would otherwise not be protected under the standard law or other intellectual property laws. The granting of compulsory license does not apply to UI2, although the introduction of this sui generis law may potentially undermine the strict demarcations of traditional intellectual property rights. It still stands as the best complement to the patent law in Malaysia. The coexistence of the utility innovation system will contribute significantly to identifying the shortcomings of the patent system and remedying them.